We have 3 judges before us on the floor of the Senate this week. Turns out that the filling of judicial vacancies is the highest single priority of the Republican leadership in the Senate. And Senator Mitch McConnell, the Republican leader, has gone to extraordinary, precedent-breaking lengths to fill vacancies. Of course, the most notorious example was when Senator McConnell, then in charge of the Republican majority, announced that despite the death of Justice Scalia and a vacancy on the highest court of the land, he would refuse to fill that vacancy for almost 1 year because President Obama was in office. The man that President Obama wanted to put in that position, Merrick Garland, from the D.C. Circuit Court, was widely respected by Democrats and Republicans alike. But his qualifications meant nothing to Senator McConnell. The end game in his mind was the chance that a Republican president might be elected and fill that vacancy with a Republican nominee. Well, Senator McConnell's dream came true when Donald Trump was elected president, and he turned around and nominated Justice Gorsuch, who now serves on the Supreme Court, to fill the Scalia vacancy. That was the most extreme example that we have in the history of the United States Senate of the defiance of tradition and precedent. A defiance by Senator McConnell with one goal in mind: to make sure that the judicial branch of our government became a political branch of our government, to make sure that as many Republican conservatives, some with the most extreme views, were appointed to the bench. That has been his goal, and he pursues that goal till this day. There are 3 nominations before us which amply demonstrate his efforts. When Donald Trump became president, Senate Republicans stopped their obstruction of judicial nominations and started moving nominations through at a breakneck speed. During the last 2 years, Republicans in the Senate have bragged about filling the courts with Trump nominees at a record pace. The Republican philosophy when it comes to Trump judges seems to be, in Senator McConnell's words, quote, plow right through, close quote, unquote, no matter how questionable the nominee's credentials or judgment. There are 3 more confirmation votes scheduled this week. Let me tell you about these nominees that they want to put on the court. Allison Jones Rushing is President Trump's nominee to fill the North Carolina seat on the 4th Circuit Court of Appeals. Now, for those who are students of the Constitution, you know that the Circuit Court of Appeals is the highest court below the Supreme Court. Allison Jones Rushing checks a lot of the standard Trump nominee boxes. She's a member of the Federalist Society, an absolute requirement if Trump is going to nominate you for a lifetime appointment to the federal bench. And this is a recurring theme as well, she clerked for a Supreme Court Justice, Clarence Thomas. 36 years old, she has practiced law for 9 years. How many cases has she tried to verdict or judgment? 4. Has she been the lead attorney on any of those cases? No. She's not a member of the Bar Association of the state of North Carolina, the state in which she would sit if she's confirmed. That is the most scant, weakest legal resume imaginable for someone who's seeking a lifetime appointment to the second highest court of the land. At her hearing, which by the way was held during a Senate recess over the objection of committee Democrats, we weren't even in town when her hearing was scheduled. Senator Kennedy of Louisiana, who is becoming famous for this, started questioning her about her breadth of legal experience. Senator Kennedy's a real lawyer. On the Republican side, he's put some of Trump's nominees on the spot, asking them some pretty tough questions about legal procedure in a courtroom. He asked her, Senator Kennedy said, I think to be a really good federal judge, you've got to have some life experience. Miss Rushing struggled to describe how her life experience actually prepared her for this lifetime appointment to the second highest federal court. Senator Kennedy made a valid point. Just because a judicial nominee meets all the litmus tests of being a real loyal Republican doesn't mean the nominee has the experience or the legal ability to be a good federal judge. It's inconceivable to me. In the state of North Carolina, they couldn't find a qualified and experienced conservative Republican judge. The federal courts are critically important. Since the vast majority of cases don't reach the Supreme Court, the circuit courts are the last word. This is a position where experience matters, and unfortunately, Ms. Rushing doesn't have enough of it. I'm going to oppose her. The second nominee is Chad Riedler, a 46-year-old attorney in the Trump Justice Department. When he was nominated to another Circuit Court of Appeals, the Sixth Circuit, it was a clear sign of the Trump administration's strong negative feelings about the Affordable Care Act and the fact that that act covers pre-existing conditions. Mr. Riedler filed the Trump administration's brief in the Texas versus United States case where he opposed the Affordable Care Act's pre-existing coverage requirement. Remember that issue from the last election? It was a big one. It might have been the biggest one. We basically said, we think health insurance should be available to you even if you don't have a perfect medical record. And who does? Hardly any of us. And certainly each of us knows someone in our family who would struggle with a perfect medical record. And without a perfect medical record, you can be denied insurance or charged premiums you can't pay unless you have the protection of the law. The law is known as the Affordable Care Act, or Obamacare. So Mr. Riedler argued that this requirement of covering people with pre-existing conditions, which benefits tens of millions of Americans, had to be stricken from the law. The brief Mr. Riedler signed was deeply controversial. Our colleague Senator Lamar Alexander, Republican, Tennessee, called the argument that Mr. Riedler made in his brief opposing Obamacare, and I quote, "as far-fetched as any I've ever heard," end of quote. Thank you, Lamar. Two Department of Justice attorneys withdrew from the case when they were asked to sign the crazy arguments in this brief. And a senior Department of Justice litigator also resigned in protest for the bizarre arguments that Mr. Riedler signed up for. However, almost immediately after Mr. Riedler signed this crazy brief, he was nominated by the White House for a lifetime appointment to a federal judiciary. What message is the Trump administration sending with this nomination? They're doubling down on their attack on coverage of people with pre-existing conditions. They are putting in a lifetime appointment a circuit court judge who will be watching for vindication. They are rewarding those who've led the fight against pre-existing coverage requirement. This is deeply troubling. And that's not my only concern with Mr. Riedler. He's also defended the Trump administration's unconscionable family separation policy. Remember that one? Remember when March of last year, Attorney General Sessions came forward and proudly announced the family separation policy? Do you remember then that 2,800 infants, toddlers, and children were forcibly, physically removed from their parents and placed in detention? That these infants, toddlers, and children were then lost in the system? They didn't keep a computer check on where they were sent or who their parents were? It took a federal judge in San Diego, California, to mandate and require this administration to account for these children. It is one of the most shameful chapters in recent American history, and of course, Mr. Riedler, this nominee, defended it. He argued in favor of the Trump administration's efforts to end the DACA program, 790,000 young people brought here as children to this country who went through all the hoops and paid the fees and qualified to have a chance to stay in America without fear of deportation. Well, it turns out Mr. Riedler thinks that's a bad idea. He litigated against the rights of same-sex couples and opposed anti-discrimination protections for LGBTQ Americans. He advocated for making the death penalty widely available and applying it to children. Argued for denying burn JAG violence prevention funds to a city I represent called Chicago. It is hard to imagine a more controversial, partisan nominee than Mr. Riedler. Yet, his nomination is going to be rammed through this week. Senate Republicans have also scheduled a vote this week on Eric Murphy, a 39-year-old nominee to another Ohio-based seat on the Sixth Circuit. Mr. Murphy is well known for his advocacy against LGBTQ rights, including the landmark Oberfeld case, in which he argued against the right of same-sex couples to marry. He has a lengthy record of defending restrictive voting laws. He's fought for laws to make it more difficult for Ohioans to exercise their fundamental right to vote, including voter purge laws and laws limiting the ability of poll workers to assist voters. I know a little bit about Ohio's experience because a few years ago, I chaired a subcommittee that held a hearing in Cleveland, Ohio, discussing their decision as a state to start limiting the opportunity of people to vote in Ohio. So I called as witnesses before my subcommittee election officials from both political parties, Democrats and Republicans, put them under oath and asked them a basic question. What was the incidence of voter fraud in Ohio which led you to restrict the access of people to vote, to require voter IDs, to limit early voting? What were the instances which led to that conclusion? They could tell me none, not one. I asked them, how many people have been prosecuted for voter fraud in Ohio that led to this? Well, maybe one several years ago, here or there, despite millions of votes being cast. Let's call this for what it is. Voter suppression, authored by Republicans at every level of government, even here in Congress, is designed to fight demography. The Republicans understand that they're not doing well with the emerging United States population, and so they're trying to restrict and limit the rights of some groups that may vote against them to actually show up and vote. And so they go to ridiculous lengths. And it turns out that Mr. Eric Murphy, a nominee, which we'll have before us this week for a circuit court position, agrees with their position on voter suppression. My Republican colleagues are largely silent about this outrageous incident that occurred in North Carolina last week. There was a glaring case of election fraud, and it involved their party, not the Democrats. It involved a gentleman whose conduct was so outrageous and criminal, they voided a congressional election. I can't remember that ever occurring. Why would the Republican Party ignore that occurrence in their own ranks and then try to restrict voting for people who, frankly, have a right, as all of us do, to legally vote in this country? Why are they appointing judges who would defend that approach? Well, I think it's because of the end game. The end game is to restrict the number of people who are going to vote in the future and try to limit those who might vote against the Republican Party. I'm troubled that Mr. Murphy, who's now the nominee before us, has declined to commit to recuse himself from matters involving tobacco. As the Campaign for Tobacco-Free Kids has noted, Mr. Murphy personally and extensively represented the tobacco company R.J. Reynolds when he was in private practice. For example, Mr. Murphy was the attorney to R.J. Reynolds on a series of petitions to the Supreme Court that sought to limit that tobacco company's liability from a landmark lawsuit in Florida. Mr. Murphy's refusal to commit to recuse himself from matters where he clearly has expressed his opinions and got paid for it, his refusal to recuse himself from that raises serious questions about whether he can serve the cause of justice. The nominations of Eric Murphy and Chad Riedler are being pushed through this week over the opposition of Ohio Senator Sherrod Brown. Senator Brown testified before the Senate Judiciary Committee about his opposition to Murphy and Riedler. He said, quote, "I cannot support nominees who have actively worked to strip Ohioans of their rights." I hope my colleagues will listen to Senator Brown. No one has fought harder for the rights and opportunities of Ohioans than that senator. It is shameful that circuit court nominees like Murphy and Riedler are being moved forward over the legitimate objections of their home state senators. Each of us as senators knows our state. We know when our state's legal community lacks confidence in a nominee's qualifications. The blue slip procedure is the mechanism we use for each state, the senators from each state, to speak as to these nominees. This last week, when it came to a circuit court position, the Ninth Circuit, the two senators from the state of Washington were denied their blue slip rights, which have traditionally been given to them in the United States Senate. That broke the precedent last week. It continues this week. The Republican Senate leadership will break every rule, every precedent, whatever is necessary to fill these vacancies. Without blue slips, the White House can ignore home state interests and pick extreme judges like the ones before us this week. It pains me to watch my Republican colleagues systematically dismantling guardrail after guardrail in the judicial nomination process, all for the sake of stuffing the court with their ideologues. The nomination process in the Senate is breaking down before our eyes. Our ability to fulfill our constitutional responsibility of advice and consent is diminished under the Constitution we've all sworn to uphold and defend. That is a shameful chapter in the history of the Senate. Mr. President, I yield the floor.